Well, today we are here on one case, Berg versus Spartan Nash Distribution Center. It is April 7th, 2026. This is oral argument through Zoom, and it is recorded, and the link will be on the WCCA website. We are here on Kathryn Berg versus Spartan Nash Distribution Center, WC 256625. The appellant is the employee. The employee is represented by Jerry Sisk. The respondent is the employer and insurer, represented by James D. Connor. I'd like to identify the members of the court. I have here to my left is Judge Christensen. I have on my right Judge Quinn. And as previously stated, I am Patricia Millen, the Chief Judge of the WCCA. Both the employee's attorney and the employer's attorney will have 15 minutes to present your opening statement. You will each start with 3 minutes of uninterrupted time to state your position. At the end of the 3 minutes, I will stop you and look to my colleagues to see if they have any questions. Are there any questions before we begin? No. Great. Mr. Sisk?
May it please the court, counsel. My name is Jerry Sisk, and I represent Kathryn Berg with regards to this matter as the appellant. This case presents what's fairly a straightforward but fundamental question. Can a compensation judge reject the opinions of every medical expert actually in the record and instead base her decision on a medical opinion that was never offered into evidence? We submit that the answer is no. And the reason this question even arises tells the whole story. Judge Surges was compelled to reach for Dr. Zeller's unsubmitted opinion precisely because nothing else in the credible record supported her conclusion. The medical records document 4 years of consistent ongoing treatment. The employee's testimony, which the judge herself found credible, establishes that her pain returned after the Synvisc injection wore off. Dr. Call's opinion, unrebutted on the critical diagnoses, establishes ongoing causal relationship to the work injury, and Dr. Vorlicki, the only IME doctor actually in evidence, reached conclusions the judge rejected as unpersuasive. With nowhere else to turn, the judge reached outside the record entirely and adopted the opinion of a physician whose report was never offered, never admitted, and never subject to examination. This is reversible error. Ms. Berg suffered an admitted work-related injury on August 12, 21. She received ongoing care for more than 4 years. I'm going to attempt to try to address 3 issues. First, the foundational error of relying on Dr. Zeller's non-admitted opinions. 2, the internal contradiction of the judge's own credibility findings. And then 3, this court's authority to make independent findings on the record. The heart of this appeal is in findings 50. The compensation judge expressly adopted Dr. Zeller's opinion to the extent summarized by Dr. Vorlicki over both doctors whose reports were actually in the record. This is reversible error. The statutory bar is clear. 176155 subdivision 1E provides that no evidence relating to a medical examination report shall be received or considered by a compensation judge unless the report has been served and filed as required by the section. Dr. Zeller's report was not served and filed as an exhibit. There's no evidence of it in the record at all. It was never discussed or examined at hearing. And again, the statute doesn't permit a workaround. The respondent's waiver argument fails. The respondents contend that Ms. Berg's counsel did not object to Dr. Vorlicki's report. She waived any objection to Dr. Zeller's opinion. But this argument misses a critical distinction. Dr. Vorlicki's report was admitted, and Ms. Berg did not object to Dr. Vorlicki's opinions. The problem is that Judge Surges expressly rejected Dr. Vorlicki's ultimate conclusions and instead adopted Dr. Zeller's conclusions. A physician who is not a witness, whose report was not in evidence, and whose basis for the opinions is entirely unknown from the record.
Thank you, Mr. Sisk. I'm going to stop you at this 3-minute point. Do you have any
Oh,
questions?
sure. So, Mr. Sisk, let me ask you about that objection. You're right. There was no objection to Dr. Vorlicki. And I get your point, what you're saying, it doesn't matter. Does there have to, given that he recounted Dr. Zeller's opinion, should there have been an objection to that portion of Dr. Vorlicki's exhibit or opinion?
No, because it wasn't the ultimate conclusion. Again, what the judge found was is basing a conclusion on a medical record summary. It's hearsay on hearsay. There was no examination of the foundation. This court well knows understanding foundational law. We look at Hudson, where if we don't have adequate foundation to be able to analyze that opinion, then how can we accept it as fact? And as fact, that's what we're using as an ultimate fact here, is for the judge to say, well, Dr. Zeller said it resolved. But that's not what Dr. Zeller said. Do we know what Dr. Zeller said? Do we know exactly what she said? It's a recitation. And again, it's not up to object to every fact within that report. It's the ultimate conclusions for which that there was an objection to. And that's Dr. Vorlicki.
Okay, so then let me ask you this then. Let's assume that the compensation judge was absolutely wrong accepting Dr. Zeller's opinion as recounted by Dr. Vorlicki, and she rejected Dr. Vorlicki's opinion, but she also rejected the opinion stated by the treating doctor, Dr. Kahn. So then can we have a basis to affirm anyway by just saying the employee did not meet her burden of proof?
No, because again, the judge here disregards unrebutted testimony. So first, if we look at the experts in the case, because as I mentioned from the beginning, she didn't like the two opinions. So she reached outside the box to find something that comported to what her thought process was. And she listed out various factors, and I'm happy to go through all of them, which again, I think don't support the conclusion that this injury resolved. Let's go to the credibility determination, because I think this is the most telling part, is that under finding, it's under finding 28 and 29, where the compensation judge said the employee credibly testified that she had complete relief of her symptoms as a result of the Synfis injection for about 5.5 months. That can't be consistent with a decision from Dr. Zeller or even Dr. Call, or I'm sorry, not Dr. Call, Dr. Vorlicki, that her injury resolved. And we also have to keep in mind, Dr. Zeller didn't see the employee. She saw him well before this injection. And Dr. Call didn't see even Dr. Call's reports, didn't see the causation opinions, didn't see any of that. So when we look at the opinions in general as to what's still standing, Dr. Call's is unrebutted. Dr. Vorlicki's opinions fall because, one, the judge didn't find them persuasive. And the facts for which the judge is relying on, that the employee's condition continued to progress. And the judge contradicts herself too, to say, well, it resolved sometimes before, but even by this to say that she had 5.5 months or 6 months of relief, and then those symptoms returned. They came back. You can't have it both ways, to say, well, it resolved, but then you have these symptoms that return 6 months later after the injection, which again is supported by the opinions of Dr. Call.
Let me ask a question. Is there substantial evidence? I think you made a note of this in your opening remarks. Is there other substantial evidence in the record to support this compensation judge's determination, just within the medical records themselves?
No. And frankly, when we go through the opinions, you'll see the memorandum that the judge relies on. And the judge starts off in the memorandum stating that the parties did not submit Dr. Zeller's IME, admitting that. Dr. Vorlicki summarizes the opinions. Dr. Zeller's opinions expressed in Vorlicki's report are more persuasive and consistent with the objective medical evidence for these following reasons. And she states out specifically various reasons. But when we go through each one individually, there is no support for it. So again, one, Dr. Zeller examined the employee and found. How do we know Dr. Zeller did? There's no evidence in the record. There's nothing in the record saying that he examined except a summary. If that's a workaround, Just think what that would do to the work comp system. I'll have my doctor summarize a report and put it in there, and then that becomes fact. Then we throw out the rules of evidence upon hearsay, and all foundational law that's required, that's solidified. Doesn't make any sense. Dr. Zeller said the employee resolved. It's not what Dr. Zeller said. Dr. Zeller didn't say that. I know what Dr. Zeller said. Does the court? No, because we don't have the report into evidence. That's foundation. 3 talks about the 100% relief of 5.5 months. And I think I've already addressed that. Is that again, she admits that there was an injury, finds the employee testified credible, says that and then had a return of those symptoms. So you can't say that it resolved when those symptoms returned. 4, Dr. Brever, and this is where we start reaching. I think when we start looking at what the judge is attempting to try to do to pull out facts from the record to support this type of decision. 4, Brever noted that the employee had very nonspecific findings in the right upper arm and right shoulder. Well, we have an admission that there was a work-related injury at that time and that it continued to play a substantial contributing factor.
Counsel, I'm going to interrupt you a minute. I am moving towards that analysis that you talked about overreaching. So we have testimony that the injection provided 5.5 months of relief. The CJ found that to be credible. The relief ends and the pain resumes. Dr. Cow recommends a second injection. The employer insured deny. And I know at that time the treatment parameters were at issue, but I know they were in closing arguments then removed from the statement of the issue case. So is the final effect of this findings in order to preclude payment for claimed medical treatment after August 18th of 2023? Do you read the CJ's findings in order as denying all future medical treatment? Because it's not clear to me what the effect is from this decision for treatment when finding 47 says we got a motion to intervene seeking reimbursement of a future claim. Never heard of such a thing. We've got another intervention in finding 48, filing a motion to intervene seeking reimbursement of future claims. And then I got an objection filed after closing 8 days later. I got a closing in October for a trial that happened in July. This piecemeal litigation, I have a request to unconsolidate, to bifurcate, to continue moving through this index. What is the effect of this decision in the findings in order that you've appealed today for all treatment after August 18th, 2023?
Well, I think what effect that this decision has, because we use the term resolved, and resolved. We're using that terminology, which the judge, in adopting Dr. Zeller's opinion, I think precludes or potentially precludes, if this is upheld, any future litigation relating to this work injury.
It's not Couts versus Sutherland, but it's clear that it's vague, if I could be so bold as to say.
Sure.
And the inference is there. If this sits in a full affirmance, can you bring future treatment? Can you bring a third injection?
Well, the question is whether I could or whether I would be successful based upon this. I mean, considering the fact that if I have to go before a judge who has already said, hey, this injury resolved, I accept Dr. Zeller's opinions, I imagine Mr. Connor, who's an experienced attorney, is probably going to get an updated opinion, probably from Dr. Zeller or anyone else, to solidify that resolution. And I don't see a judge, compensation judge, who has found these prior findings to say, hey, employee, now you've met your burden of proof. Now I think it's going to be very difficult based upon these findings and the term resolved, which is noted throughout and adopted by the compensation judge. I think that's going to be an issue. And so again, that's one of the reasons, again, why we're appealing this decision, is because of that factual finding and that adoption of a report which was never offered into evidence. And that's why we believe that this court can substitute its own findings in this case, because as I mentioned, the judge already made the credible determination, already established the facts. And the facts in this case, as it relates to Miss Berg, support that she continued to have ongoing symptoms and problems. And
what would those findings be then? I mean, because going to what Chief Judge Millen was asking, I mean, the only issue that was really apparently at trial was whether treatment with and paid for by a variety of different interveners was causally related to the reasonable, necessary, causally related. The treatment parameter issue went away. So the findings that you suggest we substitute would be all the treatment that at least was up through the hearing after August 12, 21 is reasonable, necessary, and causally related. Is that it?
correct,
Okay.
correct.
All right.
Yes.
And then let the parties figure out who gets reimbursed what or whatever it might be.
Yes, when we're looking at the benefits that are in dispute, correct. That's it. But again, we're dealing with a memorandum and findings that are in place that dictate and can establish future precedent for decisions that we have going, especially when we're looking at, again, using the term resolved. If the judge said, hey, the employee hasn't met their burden of proof as it relates to ongoing treatment or care, well, then that may be a different story. Instead, adopting an opinion of a doctor who isn't and saying it resolved, then that creates a different set of circumstances.
Okay.
And so again, that's where substituting those specific facts in this case and finding in favor of Ms. Berg is appropriate in this case. And I know I've got it limited in time here, but what I also wanted to address, because of kind of the rationale for which the judge had gone through in 6 through 11, 6, when it starts talking about the diagnosis of osteoarthritis of the right shoulder, again, which I felt was a stretch, is because that was a diagnostic code that was used for the injection. No one, not even Dr. Call, had said that she has osteoarthritis. And again, I felt like it was a reach here to try to deny the claim. Again, normal X-ray, MRI, CT scan. Again, the condition for which we're seeking, which is this desensitization, nerve injury, that's normal. It's normal to have that. Dr. Call stated that throughout the opinion. And again, keep in mind, Dr. Zeller never issued an opinion on it, and Dr. Verlicky's opinion was rejected. And again, number 8, the employee's body parts have varied. Again, that's this nature of this injury. And what I would point the court to is when we start talking about complex regional pain syndrome, RSD, to look at Minnesota Rule 5221, 6305, which talks about RSD causalgia. This is the exact type of condition for which we're looking at, where it states the legislature, the Department of Labor and Industry has told us, hey, you have a normal X-ray, MRI, CT scan, but you have symptoms that are out of proportion with the type of injury. It's compensable. And
So I'm
here's
going to
treatment.
stop you now. It's been 15.
Yes, thank you.
You may begin.
Thank you, Judge. If it pleases the court, counsel, I just want to start off by clearing up the factual record here. Your Honor pointed out that the trial judge Surges found the Synvisc 1 injection to be reasonable and necessary. And that is true. And it seems to be easy to read through the lines of the finding to determine that Judge Surges would have found another Synvisc 1 reasonable and necessary. But for whatever reason, the employee has never attempted to get one approved. And if you take a look at Employees Exhibit Bates Stamp, page 000030, it says flat out in the treating doctor's chart notes, a repeat Synvisc 1 injection was approved by workers' comp. It was requested and approved, and the employee never attempted to get it. There is not now, and there's never been a request for a Synvisc 1 injection in litigation. And as you can see from this record, it was approved. The employee just opted not to go forward with it for whatever reason. In regards to the repeated claims that the judge determined that the injury is resolved, that is incorrect. There is no such determination, and that is outside the scope of this decision. The only issues at this trial were the reasonableness, necessity, and causal relation of the medical treatment within the intervenor claims. There is no precedential value for future reasonable and necessary medical treatment. And I would just like to counter counsel's assumptions that my client would automatically deny a request for a repeat injection. I don't know where that assumption is coming from, given that the employee is evidently not interested in receiving. And it seems quite clear that Judge Surgis found that to be reasonable and necessary treatment based on the employee's own testimony that she received 100% relief from that injection for a period of 5.5 months. It stands to reason that additional reasonable and necessary treatment would involve another one of those injections rather than repeat rounds of physical therapy that weren't effective per the employee's own testimony. In regards to the reliance on Dr. Zeller's opinion as captured in Dr. Vorlicke's report, Judge Surgis did not rely on anything from Dr. Zeller's report that was not accurately contained within Dr. Zeller's opinion. And Dr. Zeller's opinions were accurately captured within Dr. Vorlicke's report, which is why there was no objection to the foundation of that report at the hearing. If counsel's argument is to stand, then no judge is ever allowed to rely on summaries provided within an independent medical examination. Say, for example, an IME doctor references a MRI from January 1st that showed XYZ, but no such MRI ever occurred. Well, then, of course, you have the objection as to the foundation, and that objection is properly made at trial.
I'm going to interrupt you there for the 3 minutes.
So continue on with that, because I have a follow-up. So
Thank
continue
you.
that line.
I have a question.
Oh,
The judges,
I have a question
Oh.
for you. So you're talking about Zeller's report. I know in reviewing the foundation letter Mr. Sis sent to Dr. Kaw that record or report was attached, as was in at least referenced in Dr. Vorlicke's report. And if I'm following what you're saying in that regard, you're looking at Zeller's report more as just a medical record that was sent to Vorlicke, also Dr. Kaw, and in that sense, even though it's an opinion letter, we don't have that report. We don't have or would have that record within the evidence submitted to us because it's referenced by or given to those doctors at it's part of the record by inference or something along that line.
I'm not saying that Dr. Zeller's entire report is part of the record by inference. I'm saying that Dr. Vorlicke's report is in the record. Dr. Vorlicke's report accurately captures Dr. Zeller's opinions, and Judge Surgis relied on those accurately captured opinions. Again, there was nothing in Dr. Zeller's report that was relied on or referenced by the judge in making her determination. If the employees' counsel found that that Dr. Zeller's opinions or summary or findings were inaccurately captured within Dr. Vorlicke's report, he had the option to object to the foundation, and he specifically waived that objection.
but Dr. Zeller, at least as recounted by Dr. Vorlicke, because that's all we have too, it's almost entirely what is recounted as her opinion and not necessarily her findings on examination or anything like that. And for her opinion to have foundation, we need to know how she got there. And we don't have any of that.
That's fair, but it's also true that the judge indicated that the actual medical records supported the findings of Dr. Zeller as captured in Dr. Vorlicke's report. It is not just Dr. Zeller's findings that she's adopting. She's adopting those findings in the context of the entire record, which includes all of the medical records relied on in making those determinations.
All right. Well, so Dr. Zeller says, and this is before that injection, I think this is going to be a temporary injury that will resolve in a few months. And that's what we know, what she says. She doesn't say, and I think she says something along the lines of, as long as she continues on with her treatment plan. To the extent of what she meant by treatment plan, I don't know, because we don't know what Dr. Zeller had. Then we know that there was an injection 3-4 months later where there was some relief for 5.5 months, which that was found from the employee's testimony, which was found to be credible. So Dr. Zeller doesn't say it resolved. She says it, I think it will. She doesn't say it's temporary. She says, I think it will be. How is that consistent with the conclusion that the care after that injection was not reasonable and necessary?
Well, I think that we're stepping a little outside the scope of this hearing again, because again, this is only in relation to the medical treatment, captured within the
Well, that's what I'm talking
intervention
about.
plans.
The treatment after that injection, that's the treatment that has been denied by Judge Surgis. How is that denial of care that began in January of 24 or 22, whatever it was, 24, I think, consistent with Dr. Zeller's opinion issued in March or April of 23?
I don't see how it is inconsistent. I mean, Dr. Zeller determined that another few months of treatment would be reasonable and necessary. That injection happened within those couple of months. And thereafter, the trial judge Surgis has the opportunity to pick and choose from the evidence available to her, including not just the expert reports, but also the medical records themselves. And she did not find the only expert medical opinion that found additional non-Synvisc 1 injection treatment reasonable or necessary was Dr. Call, and Judge Surgis specifically found that Dr. Call's opinions were based on an inaccurate foundation because they were inconsistent with Dr. Call's own chart notes.
All right. Well, and that goes to the question I asked Mr. Sisk, which was, let's forget about Dr. Vorlicke, Dr. Zeller, and Dr. Call. All those opinions were either rejected or maybe shouldn't have been relied upon if we accept Mr. Sisk's opinion about Dr. Zeller's thing. Did the employee simply fail in her burden then? Is that a basis to affirm?
Absolutely. Absolutely. The employee is asking that treatment beyond that injection be found reasonable, necessary, and causally related without a reliable medical opinion that's based on a significant or a decent foundation. We did object to the foundation of Dr. Call's opinions, and in her findings and order, Judge Surgis agreed that those determinations about reasonable, necessary, causally related treatment were not well founded. She specifically noted that Dr. Call said in her narrative report that in finding CRPS 2, by the way, that's sort of another issue here, is the reason that Dr. Zeller's report was not admitted in the first place is because it pertained to CRPS, a diagnosis the employee later dropped and then sort of readopted as CRPS 2. But that opinion...
That's your opinion, but there's no finding by that CJ that in fact that's why.
I'm sorry?
You're making an inference here, correct?
No.
What finding does she say?
She found that in finding number... hyperalgesia and allodynia were symptoms that Dr. Call recorded in her narrative that were not a part, that is finding 38, excuse me. There were symptoms that didn't exist on Dr. Call's initial examination that were cited in finding a new diagnosis 3.5 years later in the narrative report. that clearly lacks adequate foundation, and it contradicts that doctor's own chart notes.
So where does it say, what finding did the CJ state that finding contradicts?
In finding 38, it says, for the first time, Dr. Call assessed neuropathic pain of the right shoulder and sensory abnormalities and pain of the medial cord distribution overlaying the right shoulder consistent with chronic neuropathic sensitization pain and chronic right shoulder osteoarthritis. And then it's noted in the memorandum from the findings in order that, well, in finding 5, it mentions that on May 4th, 2022, Dr. Call indicated that the employee did not have hyperalgesia and lodynia. Further
Right,
down,
she's reiterating facts. She's not making a determination on a contradiction.
that's exactly what she's pointing out is the contradiction. That
Where
there
does it
was
say that this is a contradiction?
on number 11 under the memorandum, Dr. Call did not mention chronic neuropathic sensitization pain until February 19th, 2025, about 3.5 years later. She also pointed out,
Right, that's in her memorandum, which is dicta.
correct.
Okay, I was asking for a finding to find something more persuasive than the other. You know, at the time you tried this, you also had the treatment parameters as a statement of issues. Do you think that was in play for the way this case was written? And then it was withdrawn in closing argument because you had a primary denial?
Because the diagnosis changed.
Not because you had a primary denial? Can you invoke the treatment parameters with a primary denial?
You cannot. Or, yeah, no, you cannot invoke the treatment parameters if you have a primary denial of liability.
And you had a primary denial?
We did not, but we had a denial by that point. And as I understand it, the court has determined that once you deny that there's ongoing reasonable and necessary causally related treatment, the treatment parameters are no longer available to you as a defense. That's why-
Regardless of whether it's adjudicated or not?
Well, there was no
Correct.
adjudication here. And again, this is a bifurcated issue, which obviously makes this a very complicated issue for the court to determine because we still have another day of hearing. And it's
What are you going to
very-
be trying on the next date of hearing?
Well, it remains to be determined. As far as I understand, the employee has withdrawn her wage loss claim entirely. And the only other workers' compensation benefit at issue is the voc rehab, and I believe that that's been paid up through a denial that occurred only after this hearing and after this findings in order.
So I just have one more question, and that's regarding the effect of this findings and order. Does it preclude payment for any future medical treatment?
It does not.
It does not. Okay.
That's outside the scope of this hearing.
Yeah.
The statement of issues is clear that the only thing at issue is the medical treatment contained within the intervention claims.
Right. I have a
Okay,
couple
thank
of
you.
questions regarding the memorandum. The compensation judge gave various reasons why she adopted Dr. Zeller's opinion. Number 3, at the last part of number 3, she says, the employee received the injection into the junction of the glenoid labrum and humeral head, which does not explain the employee's relief of the nervous system hypersensitization throughout the armpit, elbow, hands, and fingers. Where did that come from? Did that come from Dr. Surgis, or was there some medical evidence that says that?
Well, I mean, she didn't cite to the record, so I can,
Okay.
but
I mean,
my
I
time
didn't- I
precludes
didn't
me from
see it.
going through the entire
Yeah.
medical record, but
Well,
I don't think
employee-
she made it up.
If I go back to the trial transcript, will I find that in the trial transcript as credibly testified by the employee?
Will you find that the employee credibly testified to relief from that injection?
What was
You
just
will.
stated?
You
Okay.
will. Yes.
But I mean, but I'm talking about where the spot of the injection, Judge Surgis says that's not the kind of, where she got the injection basically doesn't explain her relief. That's my interpretation of that sentence. even though she awarded the injection, which seems somewhat odd. But I'm confused by whether that came from, I didn't see that in Dr. Vorlicki's report. I didn't see it in Dr. Call's report, and I don't recall seeing it in the medical records. So are you familiar with where that came from?
I am,
As you stand there now, no.
as I'm standing here right now, I couldn't say
Fair enough.
where she
All right,
derived
and
that
then
from.
number
We
10,
got a green card, just so you know, so
Okay.
keep going if you want.
but in number 10 of her memorandum, she says one of the reasons she accepts Dr. Zeller's opinion is that neither Vorlicki nor Call said why they disagreed. Is that a requirement? Does a one doctor opinion have to say, I disagree with another doctor's opinion and here's why?
I don't think it does. I think that, as mentioned, this is dicta. So I think that she was just trying to explain her thought process.
I understand that, but yeah, okay, all right. Okay, I don't have anything else.
Would you like to?
No.
Okay. Thank you.
Thank you.
I think, Mr. Sisk, you've used your 15 minutes as well?
I believe I did.
Okay.
I'm happy to answer any questions.
I think the record is now closed. Thank you both very much for participating in this oral argument today. A decision will be issued within 90 days. Thank you.